going to talk about 5 different sections under what we deem the actual institute. I am going to handle opening and closing statements, followed immediately by me doing theme, theory, and how to try a case. I do want to give this caveat. Theme, theory, and how to try a case is typically a 1-hour program. We're not going to do that. But I do it for the SLIP program here in St. Louis in the summer. Rebecca has the same issue with regard to witness demeanor, which she will be doing later. She has a much longer program. You guys are going to get the outline version today. So we just want to give you the flavor of what you ought to be thinking about and looking for as you do various things and tasks throughout the trial. The other 2 things that we'll be talking about today that are part of the trial that Mark Harford will be handling, he's not here just yet, will be direct examination and objections and cross-examination and objections. And as was indicated early on in the program and some of the materials and emails that preceded today's meeting and conference, the questions, if you have them, raise your hand. I will repeat back the question for the benefit of those who are on the webcast. And those of you on the webcast, you will be emailing Steve Campbell through the designated means, and he'll interrupt with questions as we go along. So we may be stopping and starting throughout what is basically this lecture period for the next period of time. All right, opening and closing statements. That's, yes, the start and the finish of your side of the case. And how do you make an effective opening statement? How do you make an effective closing statement? There are a few simple rules about opening statements. And keep in mind that this applies, I work in the area of family law. When I try a case, it's what we call a bench trial. There is no jury, there's simply a judge listening. When you are doing jury work, you are talking to a jury, as would be sitting over here in the jury box, as well as the judge, although the judge isn't voting, so to speak. You have a hybrid to some degree in mock trial. Some nights your judge will be voting or writing or scoring. Other nights your judge will not, and you will be playing to the jury. Either way, there's a few simple rules that you want to consider with regard to an opening statement. This is the chance you have to tell a story. In the first few minutes, it is essentially a story about what everyone is going to hear. You're going to define the issues. You're also attempting to keep the trier of fact, be that judge or jury, interested and awake. And I can assure you, I've already seen some of you wanting to nap out here at the end of a busy day. You're trying to keep everybody listening in opening statements. The other thing you want to do is not overdo it. You don't want to overstate your case. You don't want to be too overzealous, too overly excited. It's a happy medium, a happy balance. Now, many of you who have done mock trial before, so a lot of hands go up in answer to the question here in this room, have used the evidence will show, and you use it lots in opening statement. The evidence will show XYZ, and the evidence will show ABC, and the evidence will show one time. It is recommended that you only use the evidence will show about one time in your entire opening statement. Because what you're doing in telling your story is telling the trier of fact what they're going to hear. They're going to hear from you who they're going to hear, and they're going to hear what the facts that you anticipate will be testified to. And the more times you say the evidence will show, the more times you're potentially setting your team up for failure. Why is that? Because we listen when we're evaluating and when we're judging. Because if you told us in opening statement as a trier of fact that the evidence will show something and it doesn't, the discount to your case has already happened. Before closing, before the ballot, before the scoring is completed, we've just discounted your case because you told us the evidence will show, and it didn't. Be very judicious with your use of that phrase. Not to mention, it gets boring. If I hear you say the evidence will show 18 times, it's like hearing like. Slang words, none. No slang words. No LOL, BTW. Okay, we all do this, we text, but you know what has happened? We're starting to talk like we text. Not okay. Not ever okay in mock trial. And particularly as you present this poised, important, lawyerly demeanor in your opening statement, this is not where you want to start talking text language. Texting is texting, and not while you're driving. Now you get two chances to sell this case to the court. One is opening and the other is closing. Exactly. Those are the two times when you're the one, your team is having its opportunity to sell the case to the trier of fact. What I mean by that is that you get this uninterrupted period of time to talk and to outline and to speak about what they should be listening for, what the trier of fact should be making judgments on, where they should find the evidence to weigh heavier, what's the matter with the other guy's case, with the defense's case. You're telling them in opening, this is what I want you to find wrong with the defense. Here's some problems. So this is a chance when you get to sell it, because other than that, your witnesses have to sell it, your evidence has to sell it, and your cross-exam has to take apart the other team's salesmanship. So opening is a huge opportunity for you. You want to let your jury and your judge know what's coming. You get to basically put your whole viewpoint out there in one really long paragraph. Okay, so the things that you want to keep in mind is you're painting a picture. And I'm going to go to the analogy that many of you have heard from me before, but opening statement is where you start with all the pieces of yarn that you're going to use on the loom. You are trying to start the weaving of whole cloth by the end of the trial. The opening statement, you're taking all your threads and you're putting them in order in the way that you want to use them, and you want to see the item turn out. Throughout your witnesses and your cross-exam and your direct exam and your use of exhibits, you're weaving all your facts and circumstances together. And in closing argument, you better turn out a rug, a towel, a scarf, something that took all those pieces of yarn from the opening statement and tie them together into one piece of whole cloth in the closing statement. You are painting a picture, you're giving life to your case and your parties and your witnesses, and you are giving life to your opponent's witnesses and the problems in their case. To bring it all together to say, look what I've given you here at the end. You need to find for my side, for my story, for my statement. Now, when you are in opening statement, you are able to comment on the testimony that you reasonably believe the trier of fact will hear. You may give comment. You may give essentially opinion, editorial. And I'm using those words a little more strongly for purposes of this discussion than perhaps your coaches or any of your coaches will use. You get to put your weaknesses out there and deal with them before they ever come out through the witnesses. And you also get to deal with your opponent's weaknesses. Opening statement is a place to take on the case, good and bad, and put your spin on your case. It's a spin doctor event. It's a spin letter, as we call them when we write to guardians of items and things in family cases. You spin the case the way you want the trier of fact to end up finding it. Now, the best thing to use as a framework for your opening statement is a really good pleading. So you're going to want to take a look at the pleadings that are included in your packet, and you're going to want to see how the case is pled by the plaintiff, what the arguments are. You're going to want to read carefully the other statements and, as Rebecca indicated, the rules, because this is the framework, regardless of which side you're on, for your opening statement. Here's what I need you to find, jury, and how you're going to find it is what you're going to hear and what we're going to show you. So set forth very simple facts and set them forth in a way that leads to your inescapable conclusion. You are going to find the way that I want you to because of all these things. So you're going to take that opening statement as your opportunity to line everything up and tie it all up. That's something that you can do in advance. An opening statement, I would submit in both cases, for opening and closing statement, it is easy and best to outline and write that in advance. Now, we will get all kinds of opinions from every leader in the room. But what you have to be willing to do is keep in mind, you know what you want to happen, and at closing, you also know what did happen. So you're going to write your closing statement based on how you intend to put your case on, but you need to be prepared to strike what didn't happen or didn't go well for you in a closing statement. You have to modify closing statement after each and every trial. It is not a canned speech. Opening is a little easier to that end. It's a little more prepared, but you have to fully prepare closing as well. And I'm putting both of these together because the process is very, very similar in terms of the writing. You want to keep your opening very human, very almost conversational. Keep in mind, again, you are the consummate professional. You aren't having a text conversation. You aren't sitting in Starbucks. You are being very serious. You're in a very serious place, a very serious courtroom. These are some of the finest courtrooms in the state. The federal courthouse is the most beautiful, the most imposing. And to have a judge sitting way back there, for those of you who have been in some of the final rounds, and to have a jury box full, very imposing. But you, as the person giving either the opening or the closing, have to be someone they like. They don't have to love you and want to go have coffee with you, but they have to like you. They have to find you non-offensive. They have to find you interesting, because that's how they end up finding your case interesting, because they're listening. So when you do your opening statement, you should also sit down with the individual on your team that is going to do the closing statement. And that can be written in such a fashion that many of the things you state about in your opening are then repeated in your closing. You want to be consistent. Your closing has to be consistent with your opening. But even more important, your closing has to be consistent with your trial. No trial turns out the way you think it will, in terms of 100% of your efforts and attempts. It never, ever turns out like you practiced it. It never, ever goes exactly the way you anticipated, and even with the witness statements being included here, it will not end up with the testimony word for word that you might have expected and planned for. So after you've gone through the trial, it is really important that your lawyer doing closing has the sense of things by way of again, these skills of thinking on your feet and modifying quickly and utilizing critical thinking and organizational skills to be able to modify the closing. The worst thing that we hear as evaluators in mock trial is someone telling us in closing that we heard something that we didn't hear, or what we heard, and they tell us in a very different fashion than how it actually came out. It just means you weren't listening. And for a team member not to listen tells us that you wrote your speech on your computer and you practiced it in front of your mirror and the bathroom mirror, and you talked to yourself against the door and the wall and out the window, as all of you do when you're practicing. You're all talking to invisible people and walls. But you didn't listen to what happened in the trial. Huge turnoff. Huge turnoff in this competition, because everybody knows that you have a prepared set of information, but you have to be able to think critically and respond. So now, again, you've gone through your trial and you put your witnesses on. Your closing statement is a chance for your team to tell the jury, the trier of fact, how they need to find, because they did hear the evidence will show. They heard the evidence. They heard the testimony. They heard a witness respond to a tricky cross-exam question. And they can then say, you know what, that guy or girl is absolutely right in that closing. We have to find the way that she or he said, because everything came together just like they told us in opening. You two lawyers do an opening and closing and have to work together all the time, and probably touch base through the course of the trial. If something happens and one or the other of you knows something's in the closing that it didn't pan out that way in the trial, you need to make those modifications. It's like I said, it is one of your few chances to just give your opinion and tell it the way you want to see it happen. Otherwise, you're subject to the exam process, the cross-exam process, the witnesses. So that's opening and closing statements. Now, how do you formulate those? And this is a little bit disjointed because we have topics, but I'm also going to talk about your theme and your theory and how to try a case. And this is a very brief overview of that process. But when you're starting with your opening statement, which is when you're starting with your whole case, and you have now read the entire case word for word. And not only have you read the entire case one time, you have read the entire case 2 times. And you've read the entire case a 3rd time. Read this case 3 times through. I don't know how many times Rebecca has her teams read it. They're really, really good, and you might want to ask her. But 3 times. Read it 3 times. You will catch something every single time. It is 58 pages right now. You need to look at the exhibits. You need to make notes on them. And then what you're going to do is you're going to look at the petition, and you're going to look at it carefully, or the pleading. You're going to look at it very carefully. And you're going to look at the law, and you're going to look at the rules. The things that Rebecca told you today with regard to the rules as related to this case are priceless in terms of your plan in this case. So you need to read the law to which the case is relying on, the law that the case is relying upon, that the pleadings are relying upon. You need to see the rules with regard to any affirmative defenses, contributory defenses, any of that. Look at all of those things. And what happens is, it's a little bit different in mock trial when you're coming up with themes and whatnot, because nobody's changing this case as you move along. You have your binder and you have your case ready, and a lot of things don't get changed. But when you're coming up with how you want to try your case, you need to read those witness statements. You need to read them all the way through. You need to sit down as a team and compare your notes. Each of you needs to do a T-scale of what's good about that witness, what's bad about that witness. And you need to compare with each other. What did you take from this statement? What did you take from this statement? What are pros and cons? Who contradicts whom? Does the one witness's testimony come up somewhere else? Is it supported by an exhibit? Is it supported by an expert? Those are things you all need to put your head together on. You then need to think about what are the obvious pros for your side and what are the obvious cons. What are the problems in the case? All of those things have to be ascertained for how concrete is the problem or the pro, or how fuzzy is the problem or the pro fact, the fact that's good for your case. And you may decide that you can make something fuzzy that you need to. Maybe there's enough contradiction in the case that something that appears to be a negative for your case can be turned very gray, very fuzzy, so that when you're trying to show by a preponderance of the evidence here that negligence occurred, can you get there? Is it that clear? Preponderance is a lot. Preponderance is a lot. So what you want to take is your facts and show what's not so obvious as opposed necessarily to what's so obvious. Now with regard to a theme, this is part of keeping you awake, and you guys are starting to nod on me, a couple of you out here. It's a long day, but you need a theme. What is one of the most famous themes ever in the history of litigation that has happened while you guys were alive? Not that one. How about this one? If it doesn't fit, you must acquit. O.J. Simpson. The glove in the murder didn't fit or did fit, and all you heard through the whole trial was, if it doesn't fit, you must acquit. If it doesn't fit, you must acquit. One of the most famous themes, and either you guys are too young or sleepy or something to think about, but it rhymes, it's short. All the things that you think about for using mnemonics, using alliteration, using rhyming, any of those kinds of things when you're creating a theme is very important to make something stick in your trier of facts head. If it doesn't fit, it must acquit. I will never forget that for the rest of my life. It's not possible to forget it. It was on TV, it was replayed, it was in the headlines. You're essentially trying to create that kind of sticking point in your team's case. You want everybody to know. And it doesn't have to rhyme. You can use things like repetition. Okay, alliteration is a way to repeat something. Rhymes. You can use analogies, comparisons, metaphors. The plaintiff's case is like. The defense's claims are like. Okay, all the things that you guys are learning in AP English that I couldn't possibly recall at age 47, these are things you want to call up now for your theme creation. Because this is how we don't forget what you're trying to tell us. And where do you want to blow that out? The opening and the closing. You want to use that type of theme at the beginning and at the end of your case. And then you work it in more subtly as the case goes along. You know, every time they got the chance in the O.J. Simpson trial, they want to talk about that glove, the tiny little glove for his big hand. Couldn't possibly fit. You want to use the things, the thing or the rhyme or the sound or the thought that is your theme. You want to use it throughout the entire case. Again, take this with, you know, a little conservative thought. It's just like I don't want to hear the evidence will show 734 times. You don't want to hear that exact phrase 100 times during your case, but you want to make sure people remember it. It's part of weaving that whole cloth. It's part of getting to the whole story put together at the end. And what you want to do then is make sure that each one of your witnesses both supports the theory of your case that we talked about, which is set out in pleading and the law you're relying upon, or supports your theme. They all want to be part of this big team that flows together perfectly to tell your story. It has to make sense. It has to make sense when you're finished. And I will tell you, many a time in the first round, it doesn't always come out as a story. What you need to do when you practice as a team is bring in your sister, your friend, somebody you paid off the street. You need to have them come in and listen to your case because they've never heard it before. Because you know what you think you're saying, and it may not exactly come out that way. And granted, you're going to have somebody long-suffering, giving up time to sit through your whole trial, but you need to know if that trial sounded the way that you think it sounded before you ever come to round one. You want to give it a pun trial run. You want to run through all of it and make sure it made sense and that it flows. The way that you try a case effectively, this applies to new teams in mock trial, it applies to new lawyers, it applies to new employees. How you present yourself and how you are organized may very well win the case, whether it was your first day or your first trial or your first year as a school team. It is very, very important when you try a case that your attorney presentation and organization is all thought out, is practiced, is outlined. Not so that you can read it. This is an outline. They have these on computers. Okay, I don't know how to do this, but my computer just makes an outline. But all the things that I'm saying to you in between, all I have is a headline here. Okay, but be sure that you are prepared in that fashion so you can put this paper down and glance at it and then talk about with great poise what you're telling them. And talk to the witnesses. And be firm, be decisive, be conversational. Depends who you have on the stand. So the facts are not always what you want them to be. And the witnesses are not always what you want them to be, particularly if they're a hostile witness. But if you are very calm in presentation and very organized in terms of you've got your outlines, you've got direct and cross outlines, which will be talked about later, you can get through it with great poise. And that'll win a case many, many times. Even if the facts and the witnesses aren't that great, facts and witnesses do not necessarily win the case. It is your responsiveness. It is your demeanor. The other thing that I always like to throw in here, because this is a life application, look the part. If you are an attorney, the witnesses, you may be dressing in a certain fashion and not costuming, but you may do something a little different. But you need to look the part. You should not be chewing gum. You should not be playing with your hair. Men constantly have stuff in their pockets. I don't get it, but your stuff's in your pockets. And it makes noise, and it jingles, and you like to jingle it. Don't do that. Like, empty your pocket, pretend like you're coming through the metal detector and you never want to put it back. Don't ever click your pen, because I'll probably jump up if I'm evaluating and rip it out of your hand. So these are things that are distracting. I would have pretty much come out of my skin if Rebecca had, if that was just an idiosyncratic thing that she does. I probably would have walked over and tapped her or grabbed her by the neck. But these are things that you don't want to do. Look the part. Do not be chewing gum. Don't touch your cell phone, ever, ever. You're all to cell phone age, and if not, you're to iTouch age or you're to iPad age or something. If you have your iPad on the table, I get it. It's a great tool these days. But if you're like me, you can be playing Candy Crush. And if you're messing with it a lot, I probably think you're playing Candy Crush. I don't think you're working on the track. So be very careful how you look the part. Don't be reading Facebook. Again, how you speak, how you look, how you act. Hair. You can get away with some of it more as a girl, because I'm not going to talk about hair so much, but if you're a guy, you can have long hair, you can have curly hair, you can have any kind of hair that you want, you can have no hair. But if you're a guy with a lot of hair, get it under control. Okay? That's right. Mr. Pierce always needs a haircut. He gets like one a year. But it's got to be under control, so use a good product. You need to look the part. You need to look serious. You need to look like you didn't just come in from the gym and put a tie on and it's all sideways or something. Okay? These are things that are important. They're important to win a case. And that confidence comes from the practice and comes from the teamwork. You will not be confident if you get up the first night for competition in round one and you guys have spent 3 hours on the case. It's not enough. You have to be prepared. And you have to work at home independently from your team, and then your team's really got to put some time in. You have to play off each other. You have to work together. You have to be confident in the roadmap that you just laid out. You guys are going to spend a lot of 3-hour rounds together. And you have to be prepared to support each other, have your back, make notes, pay attention at the table. Don't do a lot of writing and shoving, and that probably was not so good for the webcast, sorry. You can't be making a lot of drama at the table, but you need to have each other's back. You need to make notes if you need to tell one of your other lawyers something. And you need to make sure that if there is a very important fact missing, that you've let somebody on your team know that needs to know. Objections. Sometimes a sharp pinch in your friend's side is effective to getting them to object. And I didn't see it as an evaluator, but you're waking your objecting lawyer up as to maybe what needs to happen to sort of jazz up your side. Wake up the trier of fact. Does the trier of fact look like they're dozing? Because guess what? When we get off work at 6 o'clock and we come judge you guys, I'm pretty tired too. And so if the judge or the jury is starting to look like they're nodding off, that's a really good time to object, to stand up, to do something to catch their attention. You want to plan how you get your point across, and sometimes simple moves like that get your point across. You want to wake your people back up. Kind of like hitting that desk probably worked out. All right, after you know your case backwards and forwards, you'll still be scared. And that's okay. I've been doing this for 23 years, 22 years. And I want to throw up every morning that I have a trial. Okay, and that may not be this case for esteemed Mr. Harford, who's joined us, or Ms. Nicholson, who's here. But I want to throw up every time I get ready to try a case. So it's okay to be scared, it's okay to be nervous, it's okay to be anxious. But when you stand up in front of everybody, fake it. Seriously. Get a little fan, get a little something before you come in the room, take a drink of water, fake it. Confidence is something that can be faked. It is possible to do that. And when you know everything about your case, and you know every fact, and you know every bad fact, and you know everything you want to do with this roadmap that you have sat down and created, you will start, and all of a sudden you realize, this is no big deal. It is no big deal. You'll stop hyperventilating, you'll stop feeling like breakfast is right here, or dinner, or lunch, or your snack. It is all coming down to preparation and a plan. So be very confident, be prepared to fake it. Be respectful to everyone in the room. Be respectful to the hostile witness. Be respectful on cross-exam. It is okay to be firm. It is okay to be challenging, but don't be a jerk. That's offensive to the trier of fact. If you have really good facts and you're really getting them on cross-exam, you can do it with a level of mild snarkiness. Okay, you're telling them that you're going to take them down, you're going to use the stiletto, you're going to take apart their testimony, but you're not a jerk. Nobody likes the jerk. So you want to be careful how you do that. So be organized, be prepared. Don't be over-prepared. Because when we're talking about over-prepared, that's when we're talking about getting stuck in a rut and not thinking on your feet. You may, for all the things that I've said about knowing everything backwards and forwards and making a plan, if you get over-prepared, you will stick yourself in that rut and you will not be able to react. You will not be thinking on your feet. And that's something that has to happen. Has to happen throughout the whole case. When you destroy the opposing side, do it respectfully, do it methodically, and then in closing, tell everybody how you did it and what you did and where they failed. Give your opinion, tell the jury how to find. Any questions?
Just one addition, it's all great. One thing that's harder to do than just be confident is never let them see you sweat.
True.
Even when you lose an objection, or when the witness is giving you an answer that you don't like, or is not what you expect, you want to find a way to calmly work your way through that. I had one student on my team a few years ago, and whenever she would lose an objection, it was like she would like frown and furrow her brow, almost stamp her foot, and I mean, it was horrible. And you have to act like it's all good. In effect, you're saying, no problem, Your Honor. You don't say that literally, but you want to act like everything is still going just fine, no matter whether it's going your way or not.
Is that okay to be heard? Did you hear that on the webcast?
Don't let them sweat.
Okay, you're right. Don't let them see you sweat. And sometimes that's actually a physical event as well. So you might think about what you're wearing. I'm big on that. Okay, think about what you're wearing. If you're a real sweaty person, don't wear a color that shows it. Wear black. Wear black. Wear black today. So, but Randy Pierce is right. Retired teacher, now coaching again. Don't let them see you sweat. Be calm. Be cool. Just think about it in your head. How am I going to get through this one? Because this was sort of ugly. Be prepared with the next set of questions or the next move. Any other questions here in the room? Anything on the web? Okay, I am going to turn it over, I believe, to Mr. Harford. Mark Harford, I told you, is my co-chair from the Bar Association side, and he's going to talk to you about direct and cross, right? And the objections, and we're glad to have him. He's been doing this a very long time. Prior coach as well of mock trial teams.
Well, in defense of all the men in the room, we have a lot of stuff in our pockets because we don't have a $1,000 purse to put it in. So, I'm here to talk about direct and cross-examinations. I apologize. I was at a hearing this afternoon, so I didn't have the benefit of everything Susan had to say to you, but I hope she discussed, or if she didn't, I'll discuss it right now. The anatomy of a case is basically, the opening statement is when you're going to tell the judge, the jury, what you're going to tell them. The directs and crosses is when you're actually telling them. And then the closing is just basically you tell them what you told them. That's a case in a nutshell right there. Tell them what you're going to tell them, tell them what you told them. It's that simple, okay? Cross-examination, or actually I should start with directs. Direct examinations are for the party that is putting on their case in chief. We all know that if the prosecution or a plaintiff, you're putting your case in chief on first, so that means your 3 witnesses go first. And when you get up and you ask them questions, that's what's called a direct exam. I want you to think of that in terms of like directing a movie or a play. All you're doing is you're eliciting from the witness the facts that are applicable to the case, okay? On the top of your, if you're taking notes, on the top of your notepad on a direct examination, you do not ask leading questions, okay? A leading question is a question that infers the answer. Now, that's sometimes hard to figure out what a leading question is, but generally, it's a question that has an affirmative statement in it. Something like, isn't it true, Mr. Harford, you're wearing a red tie today? That's a leading question that infers the answer. When you say, isn't it true? Isn't it a fact? All right? A non-leading question would be, Mr. Harford, could you please describe to the jury what color tie you're wearing today? And then I would answer, well, it's a red tie, okay? That's about the most simplistic example I can give you for a leading versus a non-leading question. But on direct examination, you are listening from the witness simply that. What did they observe? What did they see? That is what a fact witness tells you. An expert witness renders you an opinion. So there's really two flavors of witnesses. And both sides probably will have an expert witness and fact witnesses. So on a direct, you're just merely trying to elicit those facts you can in a non-leading way to describe the facts you want the jury to know for your side of the case. All right? A cross-examination is the exact opposite of that. You should ask nothing but leading questions on a cross-examination. Isn't it a fact? Isn't it true? This happened, didn't it? Those types of things. Those are the kinds of questions you should be asking. And the reason that is chances are, if you're cross-examining the other side's witness, they'll tend to be a little bit hostile in their answer because they're trying to protect the ball with regard to what their case theory is for their team or whatever. So, you know, that's why you can be a little more aggressive on a cross-examination, all right? Susan said you don't have to be mean, or I can't remember exact words she used or whatever. Don't be afraid to be aggressive. Don't be afraid to try to control the witness, all right? Now, when you're talking about witnesses in general, whether it's on cross or direct, you need to understand that not all witnesses come into the courtroom with perfect knowledge, all right? Some witnesses were able to observe something. Some witnesses maybe thought they observed something, but they weren't able to. So if their testimony is coming in, you have to check their credibility. And credibility doesn't necessarily mean they're coming into court to lie, although they could come into court to lie under oath. But credibility goes to capability. Were they capable of witnessing something? And when they witnessed it, were they obscured in their vision in some way? You also want to test for bias. Is a witness biased? Maybe a particular witness doesn't like lawyers that wear red ties, okay? And maybe that's part of the case, and you want to ask the witness, isn't it true you don't like red ties? And if they admit that, yes, they don't like red ties, that goes to their bias, and then maybe their perception of that person, okay? These are the kinds of things the court's looking for when evaluating witnesses. I think the course packet shows how to qualify expert witnesses. Basically, that requires you to lay a foundation. And so if you're on direct trying to get your expert witness qualified as an expert, be prepared to have that expert tell you what their credentials are, how much experience they have in rendering an opinion, what types of opinions do they render. And then when you offer that witness as an expert, Your Honor, at this time I asked to admit Randy as an expert in high school mock trial coaching, okay? So it's a fairly specific thing he's an expert in. The other side has an opportunity to object to that, to whether Randy is an expert in high school mock trial coaching, all right? I'm here to vouch that he is, but you are too, okay? And I'm sure Susan would concur, but she's gone. So you know, experts are a little different in that you've got to lay a lot more foundation with regard to where this person's coming from and what this person's testifying to. And why is that? Because you got to find out where they're getting their information from. They didn't observe the thing, whatever that thing is, all right? But they're basing their opinion based on what other people probably have told them, what they've observed, what those other people have observed, that sort of thing. And in order for them to render an opinion on that, you know, you're allowed to go in and cross-examine them on whether they were very thorough in their investigation, whether they, you know, their standards in their profession with regard to rendering an opinion. We do this all the time in court for people, experts that come in and appraise value of property. Did they follow the standards involved in that, in their profession? Sometimes you'll find they didn't. Well, they may have a good reason why they didn't. They may not have a good reason why they didn't. Well, if you're attacking that testimony, you obviously want to exploit that. You want to go in and call that expertise into question, okay? I think probably the best way to plan a direct and cross-examination is to get together with your team and find out what your theory of the case is going to be. Theory of the case is establishing liability or not establishing liability. And then you're going to go through your witness list and you're going to say, well, from this witness we need this information. For witness number 2, we need this information. We need to establish all these things, okay? So that's more of a strategic look at direct examination, all right? And then the actual questions that you're going to ask, that's the tactical approach to eliciting those facts. So think of it in strategic and tactical terms. Same thing for cross-examination. You know, the other side's witnesses, there's little ounces of gold, usually in their deposition statements, that you can use and exploit. So you need, as a cross-examiner, to set forth, gee, out of this witness I'd like to establish 1, 2, 3. And then you tailor your questions to get to that. It's easier on cross because you can ask leading questions. On direct, it's a little more difficult. You have to let the witness pretty much put on the show. Cross-examination, it's the lawyer that's pretty much putting on the show with regard to what's being said or what facts are being elicited. So, objections. Make sure you do. Many teams are afraid to object. And don't be afraid to object. If you think a question is out of bounds for some reason, and there's, I believe, a list of all the objections that are acceptable in the mock trial rules, make sure you learn those and understand them. And anticipate when you're asking a question. The other side might object to me asking this question. Well, have in your mind the reason why you're asking that question, because, you know, even though the question may be objectable, you may have a good reason for asking it, and the judge might let you ask it. So don't be afraid to object, and by all means, don't be afraid to respond to an objection. Because the evaluator sitting in the jury box, that's what they're trying to decide. Does this person know why they're asking the question? And even though they may lose the objection, they may be sustained or overruled or whatever, you know, did they have a reasonable basis to make the objection? And if they did, you're probably going to get a fairly decent score, okay? Argumentative questions, that's an objection. That's where basically you're arguing with the witness. You're not allowed to do that. Now, cross-examination very often takes you right up to that line when you're saying, isn't that true, isn't it a fact, or whatever. That's not really argument. It's, you know, when they answer the question, you say, no, that's not true, that's not what you said, or something. That's argumentative. That's not allowed, okay? Go through the pack and make sure you understand the basis of the objections and just basically tell your story. So are there any questions? Do you have any questions? Okay. I think you'll get a lot more out of preparing your directs and crosses and actually practice them, use them, try to poke holes in them. So if you're doing a direct, have somebody else try to poke a hole in your direct. Same thing with crosses. And practice, practice, practice. And that's really all I have. So, okay. I think Rebecca is next.
Mark, you got a question or two?
Oh, I'm sorry, I didn't see that.
No, I was just gonna ask, for performance purposes, we hear both from, you know, when we have judges and attorneys give advice or whatever. Attorneys, should they use notes or note cards, or is that too distracting, or is that just bad karma? I don't know.
That's actually a very good question. I wish I'd covered it. It's okay to have a notepad with your bullet points, what you're trying to get to, but whatever you do on direct examination, don't sit there and say, would you please state your name for the record? Okay? I want to direct your attention to July 4th of 2013. That just is not good style. If you were a juror sitting in a box, you don't want to have stuff read to you, all right? Same thing on cross-examination, you know, but that doesn't mean you can't have notes with you, all right? And refer to them. Lawyers do it all the time. The best performances are always extemporaneous, with no notes, okay? Rebecca would probably lash her children on the team she used to coach if they had notes. Is that correct?
That would be true.
So, you know, it's just so you know, when we tell the evaluators what to look for prior to the competition, we say, you know, don't penalize somebody because they're using notes, but we'll tell them exactly what I just told you. They shouldn't be standing there reading it either. All right? I hope that answers your question.
Could I, if I might, the one place I would say, everybody always gets ripped on the evaluators if they use notes, is opening statement.
Oh, yes.
I would say you definitely should have your opening statement memorized, and the suggestion that I would give to kids as far as notes, particularly in the cross and the direct, what's a useful technique is if you can find a little ledge, like the end of the ledge in front of the jury box, or the end of the ledge on the far side of the judge if you're crossing, and maybe instead of using a big legal pad, maybe use a few index cards that are less noticeable, and put those cards down. And don't ever pick them up, but when the witness is talking, you look at what the next point is in your notes. And the jury's looking at the witness then. So then when the jury turns back to you, you're not looking at your cards or your legal pad. You're then about to address the witness with the next question. So you want to draw minimal attention to your notes if you do use notes. But I would say definitely get your openers to memorize. Because even though it says it's allowable, they always lose points if they're up there with a script. And it's the first impression. You know, you want to make the best first impression you can make, and that's your chance to do it. And there's no objecting in the openings, so you don't have to worry about thinking on your feet. You just have to be smooth and prepared.
Very good, very good. Good. Those playing at home, I hope they heard that. Anybody else, any other questions? Okay, Rebecca.
Thank you, Mark. I'll say that Mr. Pierce has been giving that same advice for at least 25 years, so it works. The only other thing I'd say is that I think you'll find that maybe in rounds 1 and 2, when the kids are still getting acclimated, you'll see more notes, but once you hit regionals and state, the attorneys are probably not gonna have notes. So, but the card suggestion that Randy had is one you should take to heart. And the other thing that I would say is that sometimes just having the card there, but trying not to look at it, is the security blanket that somebody needs to get through their direct or their cross. My topic is witnesses. Who's played a witness before in mock trial? I call you the hidden heroes and the unsung heroes of mock trial. You know, a big part of this program is to teach people how to be an attorney and teach people how to object and make openings and closings, but being a witness is kind of acting with strategy behind it, right? And the witnesses that we have in mock trial get the same amount of points as an attorney and can make or break a team score. And if you've ever seen a ballot after a round, you know that a witness can get 10 just like an attorney can get 10, just like an opener can get 10. So witnesses carry a lot of weight in these trials, and I'm sure that there are many mock trial attorneys who could say that their case was made or broken by a witness. So I'm just going to go through some tips real quick that I use. I'll start off by saying that the attorneys and witnesses must work together in drafting the directs and the redirects. And that means that the two of you should sit down after you've read the witness statement the appropriate number of times, at least 3. You guys are going to want to go through what Susan said with the pros and the cons and decide how you're going to formulate your direct and your redirect. And the reason that you want your witness participating in this is because they're going to be a lot better on the stand for you if you've given them that kind of share and that kind of ownership in the direct. And I also suggest that you plan out a redirect, because once you know this case well enough, you're going to know where your witness is going to get hung up on cross. And you want to just have that redirect ready. Maybe you use it, maybe you don't. But if you have it ready, your witness is going to feel a lot better. Now, the witnesses also need to know about theme and theory. They have to know how the theme and theory play in to them, how their witness statement plays into the theme and theory. If there's a certain part of the witness statement that your attorney said in opening, the evidence will show, or whatever, that's going to come out, and you as a witness don't say that, you've just made your attorney look pretty bad. So you've got to understand what everyone's trying to prove as a witness and make sure that you fall in line with that. In this case, and I know you haven't read it yet, and I've only read it today, but there are 2 prison guards, 2 experts, a sheriff, and a former inmate. So we've got some potentially unique characters that our witnesses are going to get to play here. And I think you need to be thinking about ahead of time what kind of character the witness is going to take on. As a coach, as an evaluator, I can tell you that when I see a witness get up there who has some character to the person that they're trying to portray, it helps me give them a 10, right? You want to play the prison guard. You want to play the expert. You want to play the sheriff, right? You want to get into that role and make it everything it can be, and not just be up there saying what your witness statement said, but actually acting it out, right? Acting with strategy. So make sure that you and the attorneys and you all get together as a team and decide what kind of characters your witnesses are going to be. Because I can tell you, it really makes a difference when you have a close competition and the attorneys are on both sides are really great. And then you got to look at the witnesses, and a witness with character is going to carry the day. I've gone through some of the rules earlier. There are rules that apply just to witnesses, so you're going to want to look at those, 2.2, 4.19, 2.3. I'm a rule junkie, but there's rules there that talk specifically to witnesses, so you guys are going to want to make sure you take a look at those. One of the things that I have always found with witnesses is that they think if they mess up one answer, it's just going to ruin the whole case. And they get down on themselves, and especially on cross, if they have to admit something that they didn't want to admit. And I have to tell you that I have never seen one answer sway the case either way in my trial. And I think you just have to keep that in mind as witnesses. You guys are under a lot of pressure up there on that stand, and everyone's got their eyes on you, and I just want you to think about you're stuck with what that statement says, and you're just trying to make the best of it. And sometimes you're just going to have to admit that you have this criminal history, or that you're best friends with the sheriff, or you'll see them all in there. There's all kinds of things you're going to have to admit. And you just have to act like it's a normal thing. You know, suck it up, say it, move on. Don't feel like that is going to sway how the case comes out either way. We've talked about, both Susan and Mark have talked about that you might have a rogue witness who doesn't say the right thing, who doesn't go your way. But I think as witnesses, you guys have a lot of pressure on you to keep your attorney in line. You know, your attorney is going to be up there, either like we talked about, with a note card or with no cards at all, and they're going to forget something. They're going to ask the questions out of order. They're going to completely talk about something that you've never talked about before. And you've got to be flexible as witnesses and know your statement and be able to get that attorney back on track. And no one's going to know what's happening really but you and the attorney. But the attorney is going to be freaking out inside, and you as a witness can save them. And I just want you to recognize that as the witnesses, you guys have that power. And I think that, again, as the hidden heroes, the unsung heroes of mock trial, witnesses really can carry the day when the attorneys lose track or forget what the focus of the questions are supposed to be, which does happen. The other advice I would give you is to pay attention to everyone else during the trial. You know, if you're sitting there and it's not your turn to be a witness yet, look at the judge. How's he ruling on different things? Is that going to maybe cause you a problem? Look at the jurors, the evaluators in the box. Are they falling asleep? Man, your character better be great if you've not to tell their board, right? Because you could wake them right up and they could be like 10, boom, right? I mean, you can make or break this trial by watching how other people are reacting to what's going on in the trial before it's your turn. And I think witnesses have a really great perspective because they're almost sitting in the audience before they talk, before they get up on the stand, and so they can really see everybody and kind of get a glimpse of what's going to happen when they get up and testify. So I think you have really great opportunities as witnesses to impact the trial, even though beforehand in all the preparation, everyone's talking about the attorneys and what are we going to say in opening, what are we going to say in closing. But in reality, both what we're going to say in opening and what we're going to say in closing depends upon what the witnesses end up saying. And so the witnesses have a very important role. And, you know, I really try to get my students to understand that the witnesses get to earn as many points as everybody else. And even though we maybe don't focus on them sometimes, they can really win or lose or make or break everything we're trying to accomplish. So I like having good witnesses. I like having witnesses who have character and who can be quick on their feet. You know, during cross-examination, you gotta think fast, come up with something, and hope that it fits in with your theme and theory. So witnesses are really important, and congratulations to any of you who are gonna get to play witnesses this year. Yes.
One specific thing that you said that's so useful is the last part about watching what's going on in the courtroom. And a specific tip that I suggest to students, and the smart ones use it to good advantage, is watch how the judge is ruling in cross. In other words, if you're plaintiff witnesses, especially if you're the first plaintiff witness, you don't know whether the judge is going to let you explain your answer, or if the judge is going to expect you to be saying, yes, yes ma'am, no ma'am, yes ma'am, under cross. So that first witness really, in my opinion, needs to push the envelope as far as trying to get in those little explanations that the lawyers don't want. And then the rest of the witnesses, particularly the defense witnesses, but the other two plaintiff witnesses as well, if they see that the judge is going to say, you know, the lawyer says, Your Honor, would you please instruct the witness to answer the question yes or no? And the judge says, well, I think the jury has a right to hear what the witness has to say. It's like, my God, they've opened the door. Well, they better take advantage. If, on the other hand, the judge says yes or no, well, then you better be careful in the way you choose to frame your answers. So that's a specific thing that the good witnesses will look for. And the other thing is, stay in character even after you're off the stand.
Absolutely.
Don't go talk to your fellow witnesses and resort to your high school persona. You should be that character whenever the first evaluator walks in the room until the ballots are submitted.
And I would say evaluators do judge on both of those things. So keep in mind that your goal is to get a 10, right? Your goal is to help your team and get a 10. And so the evaluators are watching you even when you don't know they're watching you. Was there another question? Yes.
When you say have a character, does that mean you can have an accent or like costumes or anything?
No costumes, yes accent. I love accents. I think you've got some good promise for some accents in this case. Any other question?
I've got a question. If I'm a witness and I just won't concede anything, and obviously I'm just trying to block the other team, and I'm getting impeached over and over again with my statement, how does that affect my demeanor with the evaluators?
For the most part, from what I have seen, the evaluators do not like that. Because you have to keep in mind that while mock trial is fiction, we are trying to make it as real as we can. So we give you, instead of, even a couple of years ago, we changed the procedural rules to local rules, which is what we call them as lawyers. We are trying to make this seem as real as possible. Not to say that some witnesses aren't mean like that in real life, but at the same time, we want this to proceed as a learning exercise, and so getting impeached all the time means you're not sticking with your statement and you're really not playing the game of making this as real as possible. And I think you will find that the evaluators will probably not only mark down the witness, but maybe the entire team for that. So it's definitely an area I would discourage people from going into.
What if I want to throw a curveball at opposing counsel and make up facts?
I think you have to be really careful when you make up facts, and we talked about this earlier in my rules section, that there are rules that tell you about how you can make up facts. So you can make up facts if, one, in cross-examination you're asked a question that requires you to make up facts, and then two, you can make up facts that still comport with your statement and still comport with the case. So if you're trying to make up something that's totally, again, outside this reality that we're trying to create with this case, you could be found that you're impeached, that you'll be impeached.
Or unfair extrapolation?
That's the alternative, right? So the first option for the attorney is to impeach you, and then if that isn't as successful as they want it to be, there is an objection for unfair extrapolation. But keep in mind that you want to try to win fair and square. I mean, that's what this comes down to. You want to win because your strategy was great, not because you're playing some game or that doesn't mean don't throw a curveball. It means throw a curveball within the rules. Don't try to do something that's outside the rules that could potentially ruin the reality that we're trying to create. The evaluators don't like it, the judges don't like it, and we don't like it. So, any other questions? Any other questions about today as a whole? We really, really appreciate you guys coming out to see our wonderful courthouse here and to learn about the new case. And by the time you get home, it should be up and ready, and you'll go, oh, that's what they were talking about when we were talking about stuff. Of course, at any time, you can email Steve with your clarifications. If you need an attorney coach from the Bar Association, please, please, please let Steve know. We will find somebody for you. Yes?
I know every year in recent years, there's been a cutoff date to submit questions of clarification. Has that date been set yet?
For right now, since we don't have the complete case out, just go ahead and read it. Any questions you have, send me the questions. We'll send them to Josh. We'll work it out and make sure that the case is good. Hopefully within a month from now, it'll be completely finished. But this way, everyone has a chance to read it, it's a chance to go over it, and then they can decide what questions they want to do. We can just do that from now until the application is due in December.
The one thing I'd warn you about with clarifications, be sure you're not telling your strategy in your clarification question. Sometimes you're going to have questions, and it's actually your strategy. So don't ask us because we have to publish it to everybody. So make sure you as a team have decided, yes, we really think this issue needs clarification and it's just not a strategy point. Because we've got some strategies given away before. All right, thank you so much, everyone. We really appreciate you coming. We hope you like the case, and see you in January.
Good luck. I was gonna say all that, but you did feel so worked out good.
And we're done.